The Statute of Frauds 1677, which has been written into more modern legislation many times, essentially says that any contract dealing with an interest in land must be in writing. Later case law said sensibly that the writing must at least identify the land in question. In this case, a fellow named Wardle sought to mortgage his property to the ANZ Bank in return for a bill facility which would let him buy out his partner in his chartered accountant's business. Later in the year, though, he declared bankruptcy. When someone declares bankruptcy, any major transactions they made in the 6 months prior to their bankruptcy can be declared void and reversed. Here's where it gets tricky. Wardle met the bank in January and they all agreed to the mortgage before that 6-month cutoff. But at the time, there were some logistical difficulties obtaining the title deed. So Wardle signed the application and left it for the bank to fill in the title details and the date of the transaction. For one reason or another, this didn't happen for about 8 months until September. So the question was, when was the mortgage actually made? If it was made on the day they agreed to everything, then the mortgage was enforceable. If it was not made until 8 months later, it was void. Justice Hill found that the document created on the day that they agreed to the mortgage did not include the necessary details, and even though there were other documents, such as the bank manager's diary note, which did include the property's details, these were not contractual documents and couldn't be referred to. His Honour said, "The present is merely a case where the only documents to which reference can be made are completely silent as to the property proposed on the subject of the mortgage. It follows, therefore, that there was no sufficient note or memorandum in writing." There is, however, an exception to the Statute of Frauds requirement for writing, and that exception applies when one party has already part performed the contract. Justice Hill found that the bank had part performed the contract by honouring the bill facility under the mortgage. As a result, the bank could rely on the mortgage. From this case, we confirm that to satisfy the Statute of Frauds, a document of agreement must at least set out the location of the land in question.